how to avoid the first-headed monster, disability probate. Oh my. Hey folks, Elder Law Care Attorney Patrick Kelleher. Today we're going to answer your question. What are end-of-life planning tools or end-of-life planning documents, estate planning documents, or tools that you need today in your Elder Law Toolbox? Folks, Patrick Kelleher, Elder Law Attorney and author of How to Avoid the Four-Headed Monster of Estate Planning and Elder Law on Amazon. Folks, pull up your chair, get your notebook and pen out, and let's learn together. What are the end-of-life estate planning tools or documents that you need today to have your affairs in order in the event you or your spouse became completely incapacitated or disabled? Folks, I often say, unlike fine wine, unfortunately, we do not get better with age. Really important, folks, to have the big 6 disability planning tools in your Elder Law Toolbox before a disaster strikes, okay? Because if you do not have those, folks, oftentimes your family will be forced to petition the probate court for things like conservatorships to manage your finances and guardianships to manage your healthcare medical affairs. Let's get started. Number 1, durable power of attorney with enhanced elder law powers is numero uno. Durable power of attorney should be designed to avoid conservatorships at the probate court. Make sure you work with an experienced elder law attorney to put the proper germane language in there. Folks want to give your loved one, your attorney in fact, your agent of your power of attorney, your spouse, your trusted most suitable children, your adult children, legal authority to step into your shoes day number 1 and manage your financial affairs if you had a medical catastrophe where you were rendered incapacitated. Otherwise, you're petitioning the probate court asking the good judge to pick somebody for you, all right? I often say your worst pick is better than the probate court's best guess because they're a busy place. Number 2, healthcare proxy. Not just the one-pager you get from the hospital, that's all well and good, but a more comprehensive healthcare proxy where your agent can do other things like maybe move you from one facility to the other, maybe manage medications, maybe even antipsychotic medications if you or a loved one were diagnosed with dementia. Pretty standard protocol. Number 3, the cousin to the healthcare proxy, HIPAA authorization, Health Insurance Portability Accountability Act of 1996, which is the Medical Privacy Confidentiality Laws. And this will allow your loved ones to get access to your medical records in a time of need, maybe to obtain a second opinion from a medical specialist if you were going in for a major surgery. Without that HIPAA authorization, they are out of luck. They are down the river without the paddle, as they say. Even your own spouse will not be able to access your medical records under the privacy laws of HIPAA. Make sure you have that authorization prepared as part of your Elder Law Toolbox. Number 4, folks, advanced medical directives, which you can really spell out and articulate your wishes. This is the cousin to the healthcare proxy. Healthcare proxy says who's in charge. Advanced medical directives, you can spell out what type of care you want in a given circumstance. That way, your healthcare agent can legally step into your shoes as your medical surrogate and avoid conflict with the medical professionals as well as well-intended family members when emotions are running high. Number 5 in the big 6 is living will, which is like a do not resuscitate. Number 6, a newer disability planning tool, which is called a spoon-fed directive, because folks, from our experience, in nursing homes, memory care units, if you are no longer eating under your own volition, the staff is trained to pick up the spoon and manually shovel food into your mouth, spoon feed you, and that can sustain your life by greater than 10 years. Folks, I'm going to give you another one, big 7 disability planning. It's called a MOLST, Medical Order Regarding Life-Sustaining Treatment. That's the acronym MOLST, MOLST. Okay, the national version is called Physician's Order Regarding Life-Sustaining Treatment or Provider's Order Regarding Life-Sustaining Treatment, POLST, P-O-L-S-T. So whatever state you are in, it could be a MOLST or a POLST. Here in the Commonwealth of Massachusetts, we call it a MOLST, and that is appropriate if you have less than a year to live, sadly. Somebody home on hospice, like my late dear mom a few years ago, home on hospice, less than 6 months to live, a MOLST form would be really appropriate. It has a lot of authority because it's a medical order, folks. It is signed off by a doctor. It's signed off by a medical doctor stating what your wishes are. D and R, do not resuscitate. D and H, do not hospitalize. Maybe D and T, do not transport. And there's some more important orders in there as well. and they print that out on bright colored paper, put that on the refrigerator so the first responders, if 911 is called, will be aware of that and know what your wishes are. Folks, there you have it, the big 7 disability planning. If you'd like to learn more, folks, go to our website, elderlawcare.com, Google Elder Law Attorney Patrick Kelleher, Big 6 Disability Planning, and you'll find some articles that I drafted and another nifty video on this subject matter as well. Folks, great to see you, and pick up a copy of our book at elderlawcare.com or Amazon, How to Avoid the Four-Headed Monster of Estate Planning and Elder Law. Thank you, folks.